Well, good morning, everybody. Thank you for attending. So this is our very short webinar today on what you can do with your technical information that you don't necessarily want to patent. For those who don't know, my name is Ben Appleton. I'm a partner at Wilson Gunn. I've been dealing with intellectual property issues, including technical information, for over 20 years. So the contents of today's webinar, firstly, we are going to go through the brief reasons why you might actually not want to file a patent application, and then we go into the options that you have if you don't file. And as you can see from this particular slide, the three main options are keeping your information confidential. That could be by know-how or trade secrets, and we'll go through that in a bit more detail. Publishing it for the world to see, or, and this is quite ironic really, isn't it, still filing a patent application. But as you'll see in future slides, there are ways of filing a patent application that will probably suit what you might want to achieve without breaking the bank or without filing really a proper patent application. So these various options are generally used for different scenarios, and of course, keeping your information confidential through know-how and trade secrets is completely at odds with the other two options there, defensive publications and filing a patent application, because they will actually be published. So it'll be one or the other, but not all of them. So why not file a patent application? If your idea is potentially patentable, it's novel, you think it's inventive, surely it's the most obvious and sensible thing to do. But not necessarily, and often it's not the best course of action. And this slide sets out some of these reasons and why you should think hard about filing a patent application or not. So the primary reason why you might not want to file a patent application is because the idea, though obviously fantastic, commercially useful, and could be protected by a patent application, is simply not suitable. And some of the reasons are given in the bullet points at the top of the slide there. And probably the most common reason why an idea isn't suitable for a patent application is that it simply gives away too much information to your competitors. They're going to know exactly what you're doing when the patent application publishes and might be able to use that information to further their own commercial aims. This is particularly relevant for ideas which are processes or manufacturing methods or anything which is undertaken behind closed doors and which, unless you publish them, could alternatively be kept secret and away from your competitors' prying eyes. The next reason is that the idea might be new, but it might actually be commercially useful, but it lacks some sort of inventive step, or inventive step is quite weak. So for example, it might just be a tweak to an existing product or process, which gives you an advantage, but it would be considered obvious to try. So filing a patent application might still be possible at this point, and you might actually get that granted patent, but it's likely to cost a lot more money, time, and effort, including lots of rounds of trying to convince a patent examiner that the idea is patentable, and the cost for doing so might become incredibly prohibitive. The third reason there is that the idea, if patented, is actually completely unpoliceable. So you'd never be able to figure out whether or not somebody else infringes your claims. For example, claims to processes that we mentioned, they're particularly susceptible to this problem. Unless it's immediately obvious from looking at a product that's been made by your patented process, most process patents are fairly unpoliceable. And the last highlighted reason is that if you have a patent for your idea, it might be too easy to design around. So it might not be too useful at stopping competitors from taking advantage of the underlying idea, even if they won't necessarily be able to copy that specific idea in the patent. There's lots of other reasons for not filing a patent application, mostly to do with costs, but I think these four reasons cover most of the bases. And the second point on this slide gives more specific examples of when a patent application is probably not worth filing. The first one, mentioned it before, processes which can't be determined whether or not your competitors are using them. So consider carefully whether or not you want to publish the idea in a patent. Your competitors might honor that patent and not use that particular process, but equally they might just use it without your knowledge. And in my experience, the bigger the player, so the bigger the competitor, the more likely they are to actually honor that patent, unless they have really, really good reasons why they think your patent is invalid. The smaller the player, the more likely they are to just carry on using that process in the background and you'll never be able to tell. The second one is for things that have ingredients effectively or multiple components that are not analyzable by competitors. An example would be a composition with, say, lots and lots of different ingredients, 5 plus or 10 plus, and which, if analyzed using current techniques, wouldn't reveal all of those ingredients. So publishing that idea in a patent application simply gives away all of those ingredients, the combination, and what the clever bit is in creating your particular product or recipe. And it simply provides your competitors with complete knowledge of your composition and the ability to glean any useful information which could help their products. The third reason to think really hard before filing a patent application is ideas which really wouldn't offset the patent costs. So if you know that your new idea won't offset the costs of obtaining patents in your desired countries, and for example, if you are filing in Europe, the US, maybe China, Japan, from application to grant, you might be looking at tens of thousands of pounds. If the costs of that aren't offset by the benefits, there's not really much point in filing those patent applications. You won't get any benefit other than possibly the satisfaction of annoying your competitors for a while, which of course isn't really going to be very good business. There are also many other reasons for not filing the applications, which I won't go through in particular detail, such as the idea itself isn't patentable, for example, software, biological processes, or you simply don't have the money to pay for a patent, or your business has decided not to file patent protection as part of its strategy for particular technology areas. So there's lots and lots of different reasons, many of which will mean that you don't want to publish, many of which mean that you are still happy to publish, but just not file that patent application. So the options for doing something other than filing patent applications, the first one, which I mentioned on my initial slide, is keeping it confidential. So I've lumped this together as know-how and trade secrets, otherwise known as confidential technical information. These are all directed to a similar thing, keeping the idea confidential, and it is a viable option for handling technical information in some cases, which we're going to discuss, but again, it's not a viable option for other cases. So what is it? So know-how, it's often called confidential technical information. It's different to normal confidential information such as customer lists and other things that don't have a technical character. It's technical information that you believe is proprietary to you or your company, and which you believe gives you some sort of competitive advantage. It has to be technical, so it can be scientific, it can be engineering based, mathematical, design based, but it's got to be technical. Otherwise, as I said, it's just standard confidential information. And it's generally useful for low level, by low level, sort of low value technical information that might give you a minor advantage, such as advantages in scale, cost, or efficiency, but it isn't worth protecting through patents because of this cost benefit ratio. It's either giving too much away to a competitor or the costs are too prohibitive for the level of benefit that is actually going to give. With confidential technical information or know-how, if you do need to disclose that to anybody, it can generally be protected through non-disclosure agreements, material transfer agreements, contract terms with employees, for example, and they're generally fine to ensure you're protecting yourself, and it's a cheap and efficient way of protecting less valuable confidential information. On the other hand, if your confidential information is really important to your business, it's generally considered protectable by a trade secret. And they're pieces of technical information which, when I say really important, they are effectively essential to your business. But again, you want to keep it secret for one of the reasons that we've already mentioned. Examples might be flagship products containing ingredients which give that product its entire technical effect and goodwill. So, for example, the one that's always touted is the Coca-Cola formula. That is a trade secret. If that gets out and is delivered to their competitors, Pepsi or any of the supermarkets, it is going to really affect their business, because people will then copy that particular formula and produce products which are almost the same taste as Coca-Cola, but probably for a fraction of the cost. It could also be a trade secret of a process which provides a huge benefit, such as the ability to make a product that nobody else can. So it has to be really has to have really significant commercial value. it's got to provide your business with goodwill, and therefore customer attraction that keeps part of your business alive. So it's not necessarily going to be a trade secret for an individual product amongst a range of 15 or 20 products. It's going to be like the Coca-Cola formula, that particular bit of information that keeps your business alive. And one of the disadvantages of trade secrets is that you really do have to have active steps in place to keep that information secret. You have to have proper processes, such as steps to keep the information to as few people as possible. Generally speaking, it will have to be, when I say as few people as possible, less than 10, preferably less than 5, and possibly even fewer people for it to be a trade secret. Different countries will have different criteria for this. There has to be documented handover steps when staff leave, processes for the use of that information and how it might be disseminated outside of that core group of people who have all of the information. You can't just rely on employee contracts saying that employees must keep the idea secret. There have to be active steps in order to do so. And because of that, you've got to really think carefully about designating something as a trade secret and whether or not you can actually keep it a secret. If not, then it probably isn't one. It's more likely to be know-how and confidential technical information, or something which a patent application should be filed in order to try and maintain that competitive advantage for the whole of the patent's lifetime, which is a maximum of 20 years. Now, in the case of both know-how and trade secrets, it's going to be very useful to document that information in full, and by in full, everything. And document that you were in possession of that information from a certain date. So it's always best to use some sort of electronically time-stamped documentation system, especially for trade secrets. It's not going to help you in terms of invalidating any subsequently filed patents to the same idea, because obviously your confidential information isn't in the public domain, but it could help you avoid any sort of patent infringement action if your competitor does happen to file a patent application in the future directed to exactly the same subject matter, because you will be able to show that you were in possession of that particular idea prior to them filing the patent application, and so you have what's called prior use of that idea. It's quite a complicated area, but it's definitely useful to document everything as much as possible. So if your aim in not filing a patent application is to keep something secret, this is effectively the only way you can do so. And again, there's a lot more we can go into on that, but it's a very short webinar, so I'm not going into the details of how you actually do that and the processes to set up, but I'm quite happy to discuss that with anybody who wants to after the webinar. So on to defensive publications, and really this is the meat of the webinar, because they're a very underused tool that are not really used by most businesses. So we're going to go through what they are, when to use them, and how to use them. So what are they? They're effectively just public descriptions of any ideas with the sole purpose of making those ideas public. And as you can see from the bullet points there, they can be pretty much in any format, but they need to be freely available. So you've got to be aware of trying to put something as a publication behind a paywall or trying too hard to obscure them, and we'll come to the reasons why that might not be a good idea. As with all things, there are lots of pros and cons to defensive publications. So one of the biggest pros is that they make it more difficult for others to obtain patents or design patents in the US for the same ideas. And a key feature is that once the idea is public, it can't be patented anymore by anybody else. So if a third party then tries to file a patent application to the published idea after that defensive publication is published, the patent's going to be invalid. They are also either free or very cheap compared to patents. So it's one way of getting something published without spending too much money. They're also a lot less visible to your competitors than a patent application, so they're a lot harder to find. And it can be quite useful, as you might still want to make it hard for your competitors to know exactly what you're doing, but you've got to be careful. You don't want to make it too hard to find, or it might not be considered a valid publication for your freedom to operate purposes. And one thing I haven't put on that slide is you can also publish anonymously. So if you don't want your competitors to know that that is your idea, but it is still a publication that stops them from getting a patent, filing a defensive publication anonymously is a really good idea. And then finally, they can actually really spoil your competitors' attempts at dominating a particular technical area, whilst not incurring too much in terms of time and cost on your part. An example here is I was looking at a patent from a freedom to operate point of view for a client, and I noticed that an examiner had found a defensive publication on one of the main research publication sites. It turns out that this was from the patent owner's supplier who they collaborated with. The supplier obviously realized that their customer was going to probably file a patent application and not necessarily own that IP. So they filed this defensive publication beforehand, which was quite difficult to find, but the patent examiner found it and stopped their customer from getting a patent and then potentially preventing them from carrying on doing what they did before. So it's really, really quite a useful way of giving yourself a bit of freedom to operate. So why not use them? Well, the two main reasons are there. Firstly, once published, you're not going to be able to patent that idea anymore in most countries. But since you've already decided that you're not going to patent and you're using that defensive publication as an alternative, that shouldn't be too much of an issue for you. On the other hand, many people do turn around and say, do you know, we wish we hadn't done that. We wish we filed a patent application because this is a lot more important than we thought originally. So you have to think really, carefully about whether or not filing a patent application is the right idea. And probably the main reason why you might not want to use them is others will then be able to copy that idea completely freely. This can't be stressed enough. You're publishing your idea freely, and in doing so, your competitors, if they locate that particular publication, can use that without any way for you to prevent them. So think really carefully about whether that's something you're comfortable with every single defensive publication that you make. If you're using them for freedom to operate, so stopping others from patenting the same idea, which generally is the main use for this sort of thing, it's also all about proof and how much detail you include. For defensive publication to work, a court must be able to confirm that the idea had been published beyond reasonable doubt before a patent application was filed. And they must also be able to confirm that the publication includes the same idea that's been claimed in that subsequent patent application. So there's absolutely no point in hiding detail if that means a competitor is likely to be able to file a patent application covering a specific example that you intend to use, but you didn't. You just published a general example, for example. So the more information, the merrier. Make sure the publication can be retrieved with common keywords relating to that process. So don't use obscure language, which wouldn't be searched by an ordinary skilled person in that particular relevant technical field. It's probably very tempting to try and cover up some of the information by using different terminology that you might use ordinarily in the course of your particular technical field. But if that means that this document isn't really searchable because typing in the word film or cover layer, for example, for packaging wouldn't reveal that because you've used something completely obscure, then it's not likely to pass this test of proof in court. So make sure it's a proper publication. It covers exactly what it is that you want to prevent other people from filing patent application for, and it's going to be searchable. And where can you actually publish? So as mentioned before, defensive publications are often harder to find than patents. Patents are, of course, held on publicly accessible and searchable databases and are searched by almost all scientific and R&D based companies, as well as all patent offices when they're examining patent applications. Your competitors might monitor your patent applications, and they probably will, and probably your product launch media as well, but they're probably not going to be monitoring any sort of defensive publications because there's so many ways that you could actually do that. So if you publish anonymously, for example, your competitors are not ever likely to be able to search for those publications by using you or your company as search terms. And so they're quite good because they're still publications and they're still searchable, but your competitors aren't really going to be able to try and focus on what you're publishing because you've done it anonymously. On the other hand, companies often try to hide their defensive publications by publishing them on rarely visited websites or making them really, really hard to find. But you've got to be really careful there. To be useful, most jurisdictions require that the documents are sufficiently discoverable to become valid prior art or state of the art. In other words, in order to render their content non-patentable. The European Patent Office, for example, requires that a document can be found by public web search engines, so not private search engines, by using one or more keywords which are all related to the technical content of that document, and that the document remains accessible for a reasonable enough time enough for a member of the public to have direct access to that document. If both of those conditions are fulfilled, the document's likely to be considered to be available to the public. So those tempted to hide the publication should be aware of the first condition. The document must be discoverable on a public search engine. If a document's hidden in the sense that it's very hard to find or it's not searchable, it's not going to form the prior art. So the more reputable the publication site, the better the chances are that a patent office or court will accept this publication as prior art. So because of that, I'd always recommend using a dedicated defensive research publication site. And that's under this low-key publications at the top. Platforms specifically designated to publish research for patent examiners. There are various sites that can do that. Platforms which are freely available but not often reviewed, but they're very stable. That's the second option. Academic journal articles, again, that's also a viable option. Academic journal articles can be quite useful, but obviously they require peer review. And so there is a danger that your research won't actually cut the mustard and won't get published. So if you know that you can get it published in an academic journal, that's a good way of doing so. But if not, you might want to go for one of the other options. If you do want to choose an academic journal, you could choose a lesser known journal, which is still searched by patent offices around the world, but it's less likely to be searched by your competitors, for example. And then the second group of sort of platforms that you can use, the tell the world publications. So they're high impact publications that the business might want to use to really broadcast an idea. Mainstream media, social media, your own company marketing material, etc. They'll all be useful for immediate publication and getting that idea across to as many people as possible, as quickly as possible. However, the big danger here is that second point that I mentioned. For it to be a proper defensive publication, it has to be around long enough so that a skilled person of a patent office can actually find it. When you publish something on mainstream media, social media, etc., it's probably very transient, it's probably very temporary. And so it's going to be deleted after a time or really difficult to find because it's been archived. And so it's not really going to be searchable other than using tools such as the Wayback Machine archive. So if you do use this method, the tell the world publications, which I don't really recommend, then make sure you take a public archive snapshot of the site or the post to create proof of publication if you need it. So which platform to use? We've gone through all the pros and cons really. Accessibility to patent examiners, anonymity or impact, depending which way you want to go, reliability in court, or cost and efficiency. I would always recommend using one of the dedicated disclosure platforms. And I've listed 3 here. So the first one is a company called Questel has created something called research disclosure. There is also a commercial entity called IP.com. These are paid publication sites, but they are incredibly stable. They've been around for 20 years. They're likely to be around for a lot longer. You pay for the publication, and it could be a set fee. It could be a per page fee, but it's accessible, and both of them have actually been used by patent offices around the world in order to find prior art. And in fact, the World Intellectual Property Organization specifically says that research disclosure has to be searched by examiners during any patent application. And IP.com has been used by the EPO and their searchers are told to use that to try and find prior art as well. So they're really useful if you want your publication to be found by patent offices around the world. You can also use free public commons, various platforms, one of which there is Technical Disclosure Commons. The problem there is you have to be really careful because many public repositories have disappeared. So over the last 20 years, I think there have been over 100 of these public repositories which have just disappeared. Anything on them is then not going to be considered prior art. So you're taking a bit of a gamble if you do put your defensive research publication on a public website and one that's free to use, because there's a good chance that halfway through your reason for doing that, the disclosure is going to disappear and you're back to square one. So I would always go for one of these paid research sites which are dedicated to defensive publications for use as prior art against patents. And in the last 5 minutes, just very quickly, I did mention that one thing you might want to do if you don't want to file a patent application is actually still to file a patent application. But the way to do this is not really to file a proper patent application. It's to file a very narrow, and I hate to say it, but possibly rubbish patent application, because patent applications are published. And it's like a defensive publication. If you file something and it gets published, it's going to be there for everybody to see. If you then happen to get that to grant, then it also gives you some degree of protection and freedom to operate. So a patent application that's very cheap to file. If you do it yourself, you only have to pay the official fees, or you can get your patent attorney to just spend 1 or 2 hours drafting an incredibly quick, incredibly narrow patent application and getting that filed. It's published. It's going to stop competitors from obtaining a future patent for the same idea. And if it's granted, even a very narrow patent, if it covers your product that you're trying to cover, provides you with some degree of protection. So at the very least, your competitors might then have to design around that particular product and probably spend more money and effort in doing so than you did in order to obtain that granted patent. A published patent application is also the most likely type of document to be searched by patent examiners. So if your competitor does attempt to patent that same idea, patent examiners will find your earlier patent, even if they don't find your research publication or any other way that you've tried to publish it. So it would hopefully stop your competitor in its tracks. And if your aim is to publish something which will definitely be found, there's no best way of doing so than filing a patent application. It's also not necessarily expensive. If you use the right forum, we've already seen that some of these paid research publication sites can cost a lot of money. Often it's sort of £50 per page. So if you have a 20-page research publication, you could be looking at 5-figure sums even for putting your research publication on one of these sites. And finding a quick and cheap narrow patent application and getting it through to at least publication is probably going to cost you a lot less if you want to do it that way. A couple of hours drafting time and the official fees in the UK, for example, might cost you £700 or £800. You've got to the stage of publication, you've achieved your aim of putting your idea out as prior art for any subsequent patent application. Having that patent application might also help with attracting licensees or investment for those entities that rely on licenses, and a narrow patent is still an asset that has value. A research publication isn't. So how do you ensure that your patent application doesn't end up becoming the usual patent money seek? And the strategy here that I put in these slides will help you to do that. So the first one is file a patent application with a very narrow claim, which might be granted quickly. If it's really narrow, instead of getting an examination report when you file, you might just get an intention to grant, in which case you've missed out probably one of the most expensive parts of the patent application process. And so doing so can help you get your granted patent and at least get your publication without spending too much money. Second one is only file in one country. Because you're doing this for a sort of defensive purpose, you don't need to file in Europe, you don't need to file in the US, you don't need to file in Japan, China with all the associated cost. You can just file in the UK, for example. And luckily, the UK is a country which grants quite quickly. So if you filed in the UK, you could do so. The official fees for filing are £160. You would then pay another £100 for examination if you really need to, and whatever costs for drafting and filing that application. If it's narrow enough, it might go straight to grant, and that's the only cost you paid for getting both your publication and your granted patent. And then finally, don't rely on it for offensive purposes. You're filing this purely for defensive purposes to get that publication and possibly to get a narrow patent granted, which covers a particular product. If you then start thinking, oh, well, I've got my granted patent now, I'm going to use this to clobber competitors, you're probably in for a world of cost and trouble. So your strategy is you're filing this for a defensive purpose. Don't rely on it to try and clobber your competitors. And that's really pretty much it. The 3 ways of doing something that doesn't involve filing proper patent applications and all the associated costs. So we've seen that there are various alternatives and that they can be used for lots of different purposes. I hope it's given you a reasonable overview of the options and the pros and cons of each, and that you can go away and formulate a plan tailored to your particular business or organization. If you've got any questions, happy to take them now, or if you wish, you can contact me after the webinar and I'll be happy to pick them up afterwards. So it just leaves me to say thank you for attending this very whistle-stop webinar, and I hope to see you in the next one, which I believe is next month as well. Thank you.